for the day is the Texas Judiciary. So, in this chapter, we're going to look at the Texas court system. Now, this chapter is just going to look at kind of the function of the court system, how it's set up, what it does, and that kind of stuff. We have another chapter where we'll look at the criminal justice system specifically and look at, some of the issues with our criminal justice system and reforms and that kind of stuff. So today we're just going to look at the structure and purpose of the courts. So the role of the court, it's a bit contradictory. We have courts that handle civil law, criminal law, constitutional law, that kind of stuff. The justice system, though, is charged with two kind of contradictory goals. One is to enforce the law and protect citizens. The other is to protect the rights of citizens, even if they are accused of a crime. And so in our criminal justice section, we're going to go into that more and talk about issues we have in our criminal justice system with, the rights of individuals not being respected, all that kind of stuff. So in the state of Texas, Article 5 of the Texas Constitution divides our court system into separate purposes. So we have civil courts. Civil courts deal with family law matters like divorces, custody, child support. Also, this is lawsuits between different parties. Criminal courts, pretty self-explanatory, deals with breaking the law and punishment. Constitutional issues, our Texas Supreme Court and some of those courts deal with, is our state upholding both the Constitution of the state and the Constitution of the United States? And sometimes those cases will make it out of the state court system and into the federal court system. And then we have appeals. So in any type of case, if you feel that the judgment was not in your favor and you feel that that was incorrect, you can appeal your case, whether it's a lawsuit, whether it is a criminal case, all of that kind of stuff. So it doesn't just end at the first decision. There's always the possibility of an appeal. The judicial system has a hierarchy, meaning that the cases typically start at low-level courts. They are set up to deal with very specific issues that we'll take a look at. And then if you don't feel that you got a fair treatment or a decision that you believe was correct, you will then appeal your case up the hierarchy to higher and higher courts. But it's up to those courts to decide if they want to take a case for review. And some of the things they look at to decide if a case is entitled to an appeal was the law carried out correctly? Were the practices of the court unfair? Was there corruption in the system? Or especially in a criminal case, is there new evidence that would cause the court to reach a different decision? So we'll take a look at how that process works in a minute. Some terms to be familiar with. Jurisdiction. If you watch Law and Order or any of those kind of shows, you've probably heard all of these terms before. Jurisdiction. The territory and types of cases over which a court has authority. So if you're in Tarrant County courts are going to have jurisdiction over your case if the offense was committed here. So if you commit a crime in Tarrant County, a Tarrant County court is going to hear that case. Now, if your case was, say, an interstate crime, like let's say drug trafficking or something like that, then the federal courts may have jurisdiction if you cross state lines. So you can actually be held responsible at different levels of jurisdiction as well, depending on the type of crime, the size and scope of it, that kind of stuff as well. Original jurisdiction. This is the court that will hear the case for the first time. This is where we get the whole trial, the whole shebang like you see on TV, where we introduce evidence, call witnesses, expert testimony, all that kind of stuff that we're familiar with. That happens in the original trial. When a case is appealed into appellate jurisdiction, we don't have a whole trial again. Essentially, what will typically happen in an appeals case is you'll have a panel of judges who will look at the circumstances of the case and make a decision based on that. There's no whole trial again. They're looking for, constitutional issues, corruption, misapplication of the law, but they don't have a whole trial again. They're just looking at the circumstances of the first case. Criminal cases, like we said, this is where the government brings charges against the defendant for violating the law. And the standard we use, or we are supposed to use, to decide guilt or innocence is beyond a reasonable doubt. So, the way this works is some of you may have served on jury duty and are familiar with this, but if you ever serve on a jury, they have very specific instructions they give you in a criminal case. And one of them is that to find a person guilty, it must be beyond a reasonable doubt. So if they introduce evidence and witnesses, and any of what they say creates doubt in your mind that this person is guilty, you're supposed to vote innocent. Or not guilty, not innocent, not guilty. Those are very different things. If you believe that you have no doubt based on what you've heard that this person is guilty, then you vote guilty. So that is the standard that a jury is held to when deciding these cases. What makes that very difficult today is, media. It's very hard sometimes in these high-profile criminal cases to find people who have not already heard something about a big case or have developed an opinion or something like that. If you think about any of these high-profile cases from the past, like, say, the O.J. Simpson trial or the Rodney King trial or, some of those cases like that, it was very hard to find people who had not been exposed to media coverage of these issues. And so that can make it very difficult to find a jury that has not already been biased by information outside of the trial. And that's one thing that happens in our country today is we have a bad habit of declaring someone guilty before they ever have their trial. The jury is supposed to come in unbiased and untainted by that information, so they really can make a decision beyond a reasonable doubt. Civil cases are a little different. Civil cases are decided on a standard called the preponderance of evidence. And what that means is which side has the best evidence and the best argument. So if you were, say, suing a large corporation for I don't know, let's say they put a bad product on the market and you were injured by that product, then your evidence that it was their fault has to be greater than their evidence that it was not their fault. So in the preponderance of evidence, it's just which side makes the better case based on the evidence that they present. So civil cases are a bit different. The criminal cases are criminal laws divided into two categories most people are familiar with. Felonies are our highest criminal offenses. Misdemeanors are lower charges, minor wrongdoings. And so the penalties for those, jail time, fines, and things like that, will be very different based on the seriousness of the offense. And in our criminal justice system, we'll take a look at those types of offenses in more detail. And then the actual crime that someone gets charged with can vary in degree based on a lot of different things. Premeditation. Did someone plan this crime out, or what did it kind of happen spontaneously? Was there a weapon used? So let's say that you get into a fight with somebody. If you just fight and you use your hands, that's assault. But it can be aggravated assault if one of you pulls out a knife or a baseball bat or a weapon of some kind, and the aggravated offense has the possibility of getting a higher punishment. The level of violence, let's say, in an instance where someone punches you and you respond by punching them back, you can make the argument that you were just acting in self-defense to protect yourself. Now, say if someone punches you and you knock them down on the ground, get on top of them, and keep assaulting them, even though they can't defend themselves, now you've gone from self-defense to assault. And so the circumstances can make a big difference in the type of crime that you may be charged with. And then was it an accident or was it intentional? If, say, you get into a car accident and someone is seriously injured or killed, provided you were not intoxicated or something like that, that is accidental. That was not your intention to harm that person. But if you get into a wreck, then let's say you were driving recklessly, you were driving insanely faster than the speed limit, like speed limit's 40, you were doing 100, or you were intoxicated or something like that, then you can be charged, even though you didn't mean to kill someone, you can still be charged with something like involuntary manslaughter because you created the circumstances for someone to be seriously harmed or killed. So, the circumstances of a crime can change the offense very drastically. So the one of the biggest responsibilities of our court system is to interpret the law. The legislature passes most of the laws, but a lot of times they're not clear on what that means. And so the court oftentimes, through practice, has to interpret the law. There are different types of laws. There's common law, which gets established through past decisions called legal precedents. And so for a high level court, that's say making decisions about the constitutionality of an issue, they'll look at how courts have ruled in the past and oftentimes use those precedents to make decisions about the future. A good example here, and this is a federal issue, but it illustrates the point really well. So in the 1950s, we had the case Loving versus Virginia. In Loving versus Virginia, the court ruled that the federal government could not restrict interracial marriage because the government had no interest in being involved in that issue. Well, in 2015, that case was cited in the argument for gay marriage, and that precedent was used by the justices to rule in a similar way to say that the government had no interest in preventing two consenting gay adults from getting married as well. So that's how a case can establish a precedent for future issues that may come up later on down the line. Clarifying the law. Here in Texas, we talked about our legislative session being so short. It's 140 days, every other year. And so a lot of times these bills are written really quickly, and sometimes they can be unclear, vague, misleading. And so it's up to the courts to determine how that law is going to be applied. A really good example. In the last legislative session, they wrote the bill about CBD usage. But one of the things that they did not anticipate was that law enforcement agencies did not have the capability, they did not have the technology to tell the difference between CBD marijuana and THC marijuana, which is the one that gets people high. And so they wrote this bill so quickly without, creating a lot of rules that now in the state of Texas, it's very hard for law enforcement agencies to enforce the law on THC marijuana because they don't have the ability to distinguish it from CBD marijuana. And so a lot of courts have thrown these cases out because the technology is not there for the law enforcement agencies. And many of the law enforcement agencies have decided to just stop going after personal use small amounts of marijuana because the law has created this issue. So that's a good example of how when the legislators write the law, if they don't pay attention to what they're doing or put a lot of clarity into the law, it can create problems for the legal system. The court also has, powers and checks and balances to make sure that the other two branches of government do not try and, violate the law, create laws that are unconstitutional, or, just provide a check on their power. And they do this to the legislature by interpreting the laws or declaring them unconstitutional. Now, the court also has to balance the interest of the state versus the interest of people. In the last chapter, we talked about the citizens in Denton voting to ban fracking. Well, the courts that heard that case had to balance the will of the people against the economic interest of the state, and they ruled in the interest of the state because of the type of implications a law like that could have. So they have to balance different interests and decide which one is superior to the other. Now, the will of the people, which we call popular sovereignty, that's supposed to be the final say-so and who has power. And a lot of times, if judges rule in a way that the people do not like, here in Texas, we can vote them out of office. And so, uh, judges in our state, because we elect them, they have to be cognizant of what the people want. Another good example here in Tarrant County, some of you may be familiar. A few years ago, there was the issue of the affluenza team. If you don't know this case, there was a kid named Ethan Couch in Tarrant County. He was driving around one night with his friends, drunk as hell, and crashed his big truck into a car uh, and killed 4 people. Um, when he went to trial, the judge found him not guilty, or no, I think he was just given probation. But essentially said that because this kid had grown up wealthy and had never been held, had never, faced consequences for his behavior, that his wealth essentially made him incapable of being responsible and understanding why what he did was wrong. So he was given probation instead of jail time and that kind of stuff. And that judge was voted out of office in the next election because people just thought that this decision was ridiculous. And people called it affluenza, saying that because he was so wealthy, he got special treatment. So judges have to think about this in the state of Texas. If they upset the people, that's a good way to lose your job. So, now the structure of the courts here in the state of Texas. We'll start with the local courts. And the lowest level of courts, and many of you may have some experience here, is the municipal court. These are the ones that are established by cities and towns to deal with the most minor infractions of the law. This is typically traffic issues. So they have jurisdiction over city ordinances, things like making sure your grass is mowed and all that kind of stuff, and Class C misdemeanors where the punishment is only up to a $500 fine. So this is most of our speeding tickets, running a red light, all that kind of stuff. And most of us have been there and have dealt with the municipal court. They have the highest volume of cases in the state, but most of the cases are uncontested and the tickets are just paid with nobody appearing in the court. So one of the things that you should always do, and I tell my students this, is if you get a traffic ticket, fight it. Show up to court and fight it, because they're not really anticipating you to do that. A lot of times, let's say that a police officer pulls you over for speeding. They have to appear in court to testify against you, and a lot of times they don't show up to court. So you can actually get out of those tickets if you actually just show up to court to fight the ticket. But most of us, we don't want to take the time off of work and that kind of stuff, so we just fill out the form, pay the ticket, and move on with our life, or you can do like defensive driving and things like that. But a lot of times, if you just fight the ticket, that's a good way to get out of it. Justice courts, they are overseen by Justice of the Peace. So Justice of the Peace does more than just marry people. These are small civil claim courts up to $10,000 in criminal offenses that are punishable by a fine but no jail time. In 2015, these courts had 2.3 million cases. Most of the cases will be uncontested or dismissed just because they don't have enough evidence or things like that. The purpose of these two courts, and a lot of people will tell you that this is not the case, but these courts generate a lot of revenue for the state and for cities, because if you don't show up to contest your ticket, you just pay your ticket. That's money that goes in the pocket of the city and the county and the state. So when people say, you'll hear police say that they don't have quotas. They do have quotas, and that's why you see people getting pulled over in large numbers. At the beginning of the month or the end of the month. Because they're trying to hit their quota. They're trying to generate revenue for the state. So as much as they like to tell us they don't have quotas, those of us who have worked in government know they do. But yeah, one way to get out of those is just to show up and fight your ticket. So that's some advice from me. County trial courts. This is where things get a little more serious. First, we have the Constitutional County Court. This is not a court that really hears cases. This is an administrative body for the county. They do not hear cases. They just make decisions about the budget, administration of county government, issue beer and wine licenses. The closest thing they get to a trial is admitting people, forcibly admitting people to hospitals for the mentally ill and guardianship issues and things like that. But most of this constitutional county court is made up of a county judge and a 5-member commissioners court that essentially are just kind of like the governing body for county government. So their name's a little misleading. They don't hear trials. We don't get to that until we get to the county court at law. They have original jurisdiction over civil cases between $200 and $200,000. So that's a very wide gap, there. So they're going to hear a lot of different civil cases. And then if you, say, get a decision at a municipal court or a justice court you don't agree with, this would be the level of court that you appeal that decision to. Probate courts are courts that just deal with a person's last will and testament, some guardianship issues if people can't take care of themselves, like older individuals and stuff like that. There's only 18 of these statewide. They're probably the least busy courts because they only deal with very specific circumstances of the law. State district courts are the ones that handle most of our major criminal issues and big civil cases. So this will be your felony criminal cases, your civil cases with monetary issues over $200, but most of the time they're dealing with cases in the hundreds of thousands or millions of dollars. These are big lawsuits between corporations and things like that. The majority of cases that this level of court sees at the criminal level are drug cases. One of the things you'll hear about courts nationwide is that courts are overwhelmed by cases. Drug cases make up the vast majority of those cases, and that is why you see some places, even here in Texas, like Dallas County, that have reduced the charges for, say, marijuana to a fine and things like that, because it's a way for them to get drug cases out of their system so that they can deal with more serious issues. But, other drugs like meth and cocaine and heroin and stuff like that, those still carry pretty heavy criminal penalties, and they make up a large amount of the cases that take up the court's time. Our court system is very overburdened by the amount of cases that it has to deal with in a given year. In the civil level, these courts have jurisdiction over divorces and other family matters like custody. So the civil side is also very busy as well. In a criminal case, it's something to keep in mind. Hopefully none of you ever come into contact with the criminal justice system, but these cases can be decided in two ways. The default in a criminal case is a jury trial. 12 individuals selected to serve on a jury to determine your guilt or innocence. If you go to a jury trial, jury trials have about a 63% conviction rate. But you have the option to waive your jury and let the judge make the decision. This is a bench trial, and the judge decides your guilt or innocent and your punishment. And this has a 97% conviction rate. Now, a lot of people say, why would it be that high? Well, if you think about the state of Texas, judges here have to run for office. And one of the things in our state that judges run on is being tough on crime. And so if you have a judge who is not sentencing people to jail and punishing people the way the public wants them to, there's a good chance that judge could get voted out of office. So if you're ever presented with this decision, always go jury trial. It's easier to produce doubt in one of those people than it is to convince a judge not to punish you harshly. The appeals court. So like I said, they review the decisions of lower courts to see if the legal process was carried out appropriately and in line with the Constitution. Like I said, at this stage, there is no new trial. Essentially, your attorney files a notice of appeal and a brief with all of their arguments about why they believe this case should be granted an appeal. The judges make their decisions solely based on those briefs, or they can allow for short oral arguments by attorneys, but a lot of times it's just going to be based on the briefs. They will issue an opinion, which essentially says why they ruled a certain way. This will be a panel of judges, so they will vote, and of course, the side with the most votes, that is the opinion that is enforced. So, if you file an appeal in your case, and of the three judges, two of them rule in your favor, then the case goes in your favor. But they will issue an opinion stating why they ruled the way they did, maybe citing other cases and that kind of stuff as well. If a lower court decision is affirmed, that means that the appeals court agreed with the previous decision. So nothing happens. The original court's sentence or whatever is carried out the way they intended. If the decision is reversed, a few things can happen here. The appeals court can completely overturn the decision and let the issue go. They can refer it back to that court, maybe for a new trial, a new jury, all that kind of stuff. So it just depends on what the appeals court decides. When your case goes into appeals, you waive your right to double jeopardy, which means that you can't be tried for the same crime again. At this stage, the justices in the appeals court can order a new trial with a whole new jury and a whole new judge. So that can happen. Only about 10% of cases will make it to a high level of appeals. The process, unfortunately, favors those who are wealthy and well connected. To get, when you get into this level of the court system, you've got to have good attorneys, and good attorneys cost a lot of money. Also, what we see is, defendants who are large campaign contributors were 7 to 10 times more likely to have their case heard. And this comes from Texans for Public Justice, a nonprofit group that monitors corruption in our criminal justice system. Intermediate appellate courts here in the state of Texas. Texas is split up into 14 different districts. The courts are overseen by a chief justice, 2 associate judges, but for big issues, they can often add more judges if they think more input is needed for a very serious issue. Appellate courts of last resort, this would be the Texas Supreme Court and the Texas Court of Criminal Appeals. These are the 2 highest courts in the state of Texas. The Texas Court of Criminal Appeals deals with criminal justice issues. So they are the final determination in criminal matters, including the death penalty. This court is made up of 8 justices and a presiding justice. 4 or more have to vote in favor of hearing a case. Here in Texas, we also have mandatory review, which means in an original criminal case, if you are given the death penalty, your case gets an automatic appeal. So 80% of the Texas Court of Criminal Appeals caseload is made up of mandatory review cases. This happened after, for a while in the 1970s, the death penalty was suspended by the federal Supreme Court because we felt it was being over-applied discriminatorily to African Americans. Once the death penalty was reauthorized, most states implemented mandatory review, where every death penalty case gets at least 1 automatic appeal. So it's kind of a check to make sure that people who are being given the death penalty, there's evidence that supports it, all that they're essentially being treated fairly under the Constitution. So this is the court that deals with that in the state of Texas. The Texas Supreme Court deals typically with issues of the constitutionality of issues, very large monetary cases, or juvenile justice. This consists of 8 justices and a presiding judge. 4, again, must vote to hear a case. Only about 10% of cases in our state will ever make it to this level. Now, if you don't get a decision that you like in the Texas Supreme Court, say it's an issue of the Constitution, you can then appeal your case into the federal court system, and it has a possibility of going to the U.S. Supreme Court. But even less cases will ever make it to that level as well. Now, some criticisms of justice in the state of Texas. Our criminal justice system is massive. And there are some things that make the criminal justice system, are some areas where it could be improved. Not just criminal justice, but the justice system overall. One is caseloads. The justice system in Texas is overwhelmed. Like we said, most of the cases at that state trial court level are drug cases. And so, especially in the criminal side, what happens a lot is, you know, when a case is filed, somebody may wait 2 years before they get a trial, which means they either pay bail and get out of jail and wait for their trial at home, or if they can't afford bail, they sit in jail, even though they haven't been convicted of a crime. They have to sit in jail until their trial happens, and so this can become this is very difficult for people who are not wealthy. Even middle class people don't always have money to pay bail and things like that. So there's been a lot of call for bail reform in most of the states, that this process unnecessarily affects people without money. Um, looking at 2015, the average time it took for a case to be, from when it was filed to be disposed of, which means it's heard, dismissed, or whatever, was 650 days. So that 650 days, someone could be sitting in jail if they can't post their bail, waiting for their case to be, something to happen with their case. And so during that time, if you have like a family to support or things like that, that can really mess things up for somebody. Um, so yeah, we'll talk about some more of those issues in our criminal justice section. Salaries. Here in Texas, like we said, we don't pay our government officials a whole lot. So it is very difficult to attract quality legal people to our judicial system. In the state of Texas, our highest level of judges top out at $175,000. You think about somebody who is qualified for that position, to say serve on the Texas Supreme Court. That person can go work in the private sector as a high-powered attorney and make millions of dollars. So it's very hard to convince those people that they should leave that and come work in government for $175,000 a year. So the people that do get elected and serve as our judges may not necessarily be the most qualified and the most competent, and that's a problem as well. Turnover of judges. Many of people who will take these positions of being a judge, they do so for the prestige and the importance of the job and the name recognition and all that kind of stuff. But there's two reasons why judges leave, and that's elections, because they have to run each, every 2 to 4 years for their position. And most of them are legal professionals. They didn't sign up to be a politician, and so they don't like the process of elections. And then the other issue is the salary. The salary is very low. They can make far more money in the private sector. Another big area of concern is access to judges. Because our judges are elected, people can essentially buy influence with them by contributing to their campaign. So this system favors the wealthy, because the wealthy contribute to campaigns more. They're better connected. And so there's a gap between the way the wealthy are treated in the justice system and how the poor and the middle class are treated. In the state of Texas, in the United States, you get an attorney whether or not you can afford one. But again, the quality of that attorney is not guaranteed, and your prospects are much better if you are a wealthy individual. Judges can be elected and appointed. In states that appoint judges, they use merit selection. So they look at their qualifications, their education, their experience, and appoint them. In Texas, most of our judges will be elected. So really, there are certain criteria you have to meet to run for different positions. But if you can get elected, you can become a judge. The governor can typically only appoint a judge in the event of a vacancy or emergency to finish out a term, because we can't afford to have judicial positions empty. On the highest courts, justices serve 6-year terms. At the lower levels, 4-year terms. And then the elections are staggered so that not all of our judges are up for re-election at the same time. We do have the Texas Code of Judicial Conduct, which makes the judges accountable for their behavior and sets guidelines for removing them, such as inappropriate political conduct, and prevents them from pledging allegiance to, you know, they can run as a Republican or a Democrat, but they're not supposed to sign pledges or make promises because their job is the law. It's not about politics. Violation of these principles can lead to sanctions, fines, or being disbarred so that you cannot practice law in the state of Texas. We have a few ways that judges can be removed from office. We have the State Commission of Judicial Conduct, a commission of 13 people made up of judges, lawyers, and citizens who can investigate claims of misconduct and have judges removed from office if they violate those, the criteria set in the Code of Judicial Conduct. The Texas Supreme Court can recommend judges for removal by the governor based on their behavior and whether they have upheld that code of conduct. And then legislative impeachment. The legislature can impeach a judge for willful neglect of duty, incompetency, habitual drunkenness, oppression in office, or other reasonable cause. So there is several mechanisms for removing a judge from office. Now, qualifications. Qualifications vary depending on the level that you're serving at. Lower courts have the least requirements. Our municipal courts, the justice of the peace, those positions, you don't actually even have to have a degree in the law. Municipal judges, because they only deal with like traffic tickets and city ordinances, they don't have to have a degree in the law. The offenses are so minor, the punishments are so small that it's just not required. The justice of the peace and the county judges and municipal court judges, most of them will go through so many hours of training each year, like 80 hours of training, to stay current on the law so that they can enforce it correctly. And the Constitution says that they shall be well informed of the law of the state, so that's why they go through this education process every year. Once we get to the county court at law and higher, candidates have to have at least 4 years experience as a lawyer or a judge. At the highest levels, it's 10 years. And then we have age requirements as well that you can see there in that chart. So now people have criticized the fact that we elect our judges in the state of Texas. And these are some of the issues that we have with judicial elections. In Texas, for a very long time, we've had one-party dominance in most of the state, and especially at the higher level, where Republicans have dominated for about the past 30 years. And so it can make the courts very one-sided towards one political ideology. Even though judges, are supposed to be, reviewing the law from an unbiased point of view, they still have their own political beliefs, which can influence how they make their decisions. We have low voter turnout. Most people, when they go vote, they may know about the big races, but not know anything about the judges. And so we don't necessarily have an educated public electing judges. They just kind of vote based on party affiliation. If they happen to know a judge, it will be because of name recognition, not because they know what that judge stands for. And so name recognition can get people elected as well. Talked about conflicts of interest, where raising money can essentially allow people to buy influence with a judge, and that's one of the biggest criticisms of electing judges. Judicial experience has less to do with an election than party affiliation. So most people are just going to look at that letter by the name, and if you're a Democrat and you see the D by the name, you may vote for that person, even though that person has less experience and less qualifications than the other person, and vice versa. Money. Judges, just like every other position, need to raise money, which makes them open to lobbyists, interest groups, and all that kind of stuff as well. And then in Texas, we have this pressure to be hard on crime, tough on crime, and so it leads to harsher sentencing practices in our state than in other states that don't necessarily have this same mentality. With the death penalty, we use the death penalty more than any other state in the country, and it's just kind of our culture of being tough on crime in the state of Texas. Now, looking at the makeup, these statistics are a little outdated. Looking at who makes up, judges here in the state of Texas. This information was current as of about 2016, but in 2018, we had a record number of women and people of color elected in that particular election. So these numbers are a little different now. But a few years ago, about 4 years ago, women made up 36% of the Texas bar, so that's people who practice law in the state, and 38% of judicial seats in Texas courts. So there were actually more women as judges than what we were seeing practicing the law. And in 2018, there were a record number of women elected to judge positions. If we look at Harris County elected 12 African American women to judge positions in that county. So we are seeing this change, and so that percentage is probably a bit higher today than it was in 2016. African Americans make up 5% of the state bar, 4% of judicial seats. I believe that number has grown as well. Latinos, 10% of the state bar, 17% of state courts. So we have a higher ratio of judges to attorneys in the Latino community. And then Asians are probably the one group that are still lagging behind in representation. 3% of legal practitioners, but only 1% of judicial positions. So they're probably the most underrepresented group in the state. And then some suggestions for reform. And we'll talk about these again in criminal justice, but as it relates to criminal justice. Here, just about the election of judges. The first suggestion is nonpartisan elections. Take away the Republican or Democrat indicator by a judge's name and have people vote based solely on the name. That way, the idea is that it may force people to educate themselves more about who's actually running. Neither party wants this to happen. Public financing. Have judicial elections solely funded by taxpayer money. That way they are not open to outside influence. And this is one that has a lot of support among judicial reform advocates, but not so much, here in the state of Texas by the government itself. Limit fundraising. Limit the amount of money that individual donors and law firms can contribute to a judicial candidate. Some of the biggest contributors to judicial elections are law firms that will eventually be arguing cases before these judges. So we should limit the amount of money that they are able to give to specific judicial candidates. And then, of course, the last selection is to not use elections, go back to merit selection, and use qualifications to appoint judges rather than having them be elected.